for some reason I did already, I think 4 conferences in Maastricht this year. More than I've been in Leuven. So I went to the job when I was here.
Oh yes.
So who else is on the program?
I need to remember this.
Pratiksha, they should come. Juan Pablo is on.
We are sweeping each other.
Yeah. That should be the discussant. Juan Pablo. It's not there, I think, yet. See. No. Yeah, anyway, we have more time, so we just wait.
Work in English as well, or is it all in Flemish?
No, my research is in English.
So PhD in English.
Yeah. But we have quite some teaching duties, and those are mostly in Dutch because we teach mostly in Dutch.
The undergraduate studies are all in Dutch, right?
Yeah, but also the masters we have some courses in English, but in general, the most is in Dutch. But you may know the language is a bit of a difficult issue in Belgium.
Yes, so French also.
Everyone. And then you still apply to write for exam in Dutch.
Really?
Yeah.
What's French course? French law?
We have all law de droit in French. And that's basically how judges make decisions. So it was quite interesting. Yeah, we have one professor who's doing research research on like empirical studies, trying to see like correlations between when judgments are being made.
Can I just take a name?
I just want to let you know that I'm here, but I'll be back in 2 minutes.
That's good. We all wait.
When they just have questions.
But that's why we find was between equal and they were like like this exactly. Right. Yeah. Like, do you know?
Right, your who is extending it? Yeah. What else? There will be like a criminal more like more living in
That's quite scary.
Yeah.
I'm going to be
B2. 73.
7-3.
Yes. Yes. No, that's the one. 73.
Yes.
Great.
Yes.
So. No. Take all by. You have to stay. 1 second. Are you going to present the second time? Yeah.
Oh.
There's one there to look at. No, yeah, it wasn't working.
Yeah. So, we have to wait for Pratiksha. He was here.
He was here?
Yeah, she had to go out for 2 minutes. Okay. She's there. 2 people are online already.
Okay.
That need to be online.
From Pablo, yeah. Okay.
From Pablo and from David.
Hi everyone, I'm Juan Pablo.
The present work. Aha. You also sent it from you.
I sent to Elke.
Ah,
I
okay.
don't have it on my USB stick.
Probably the USB is easy. Yeah. Then for the second, let me check. Still need to open my email. I will see after this.
It's on the other side. Yes.
Yeah. Yeah,
My turn.
Oh, let's look at this.
I realized.
Okay, great.
Very high tech.
Okay.
I was here in the morning.
Ah,
It took me half an hour to figure it out. Don't worry.
USB.
And then the first one.
Oh. No,
Yeah, I think it's yeah.
I did though. Ah. Now we have to share through Zoom, but let's first see if it's really there. Yeah. Starting up still. Yeah, okay. Back to Zoom and then share. Screen. Yeah. Okay. Yes.
You have a point or
No, I'm the Zoom moderator. The chair is. No, we have two people for every session. That's it.
Oh, so okay. Okay, so how much time do we then need to leave? When do we need to leave here? 5 minutes before. Okay. Okay, but so perhaps like even like 3:05 we need to shut down.
3:15, we need to be stepping up. And
Wait.
maybe 3:10.
And it's 3 here? We should.
Here.
Okay. Well, I can practice.
One more time. No, it's okay. Lucky we have one. Yeah, exactly. Okay,
Good.
okay, well, in that case, should we start because we are already a little bit late? Clock is ticking. Should we close the door or we leave it open? Let's also check if everyone can hear us. People at home or at work. Pablo, Juan David, can you hear us?
Yes,
Yes.
I can. This is
Great.
one. Yeah.
Yeah, me too. Thank you.
Okay, well, good afternoon to this last panel of the day. We are the only thing that stands between you and the weekend. So I think we'll jump right in. We have our first presentation from Justine Higgins on a very interesting topic on playlists, competition, copyright. It should be very interesting.
How can I
You would have to.
Swipe, hopefully. Wow.
Or you could just take the cable in.
okay, that might be a bit more easy.
I'll make this small. Yes,
You just take the cable here.
So, good afternoon, everyone. My name is Justine Hakens, indeed. I'm from PhD researcher from the KU Leuven, from the Consumer Competition and Markets department. I just started my PhD in October, which is on a bit of a different topic than what I will be presenting on today. I wrote a paper last year with Pratiksha van Herpen, also from KU Leuven, IT professor, on playlist composition through the lens of copyright and competition law. So that ties in well with the main topic of our conference. So I will be presenting the paper today. If you want to read it, you can find it here. Unfortunately, it's in Dutch though, so it might not be very easy, but if you want, I'll help you translate it. And otherwise, I'm sure there are multiple AI tools available to help you understand the paper. To give you a bit of an overview and structure of what I'll talk about today, I'll start by giving you the background of the music industry, because it's quite a complex ecosystem with different players, actors at different levels. And I'll try to explain that a bit more to help you understand the rest of the presentation. And then I'll focus specifically on Spotify and the way the platform works, specifically with regard to playlists, how they are being composed, and what the discovery mode exactly is. And as I'll explain to you, that's a tool that came with a number of concerns, which inspired us to do a bit of a legal analysis of the tool with regards to both copyright and competition. So let's get started. So this is a bit the background of the music industry. So as you can see, there's different players involved. We have Spotify, which is a music streaming service, of course, so a platform where you can find loads of music, songs, now also podcasts. But the platform does not enter into contracts directly with artists. This goes through commercial intermediaries. For this, you can think of the recording companies like Sony or Universal Music. We also have a bit more independent, that are the digital distributors like CD Baby, for example. It's a bit less known. So the artist grants a license or right to use their music to the commercial intermediaries, who then grants a sub-license to Spotify. So important to remember, there's no contractual relationship between the artist and Spotify. So what happens when a song is being played or streamed on the platform? Spotify, of course, is paying royalties. They pay this to the commercial intermediaries. And this is approximately €3 for 1,000 times that your song has been played. So of these royalties, that means that Spotify would keep sort of a commission for itself from about 30% of what the revenue actually is. Then this goes to commercial intermediaries, who of course also take their bits, and the artist then gets the remainders, which could be a fixed fee or a percentage, or a combination of those, depending, of course, on the contractual relationship with the commercial intermediaries. Now, Spotify, I'm sure you all know how it works, of course. It's a platform where you can find a lot of music. And it's very popular. It currently has about 500 million monthly active users, which is quite a lot, worldwide. And it also has a very broad portfolio of available songs, over 100 million. That means that users, listeners can find basically everything that they might like on the platform, so to say, but it also makes it very difficult to actually find a song that you might like. You know how it works. They have a home screen where you can search for a song. But you can only do that if you already know the song you want to listen to. And you can't just start listening to music, or you can't go to 100 million songs to find something that you might like. So that leads to a choice overload, which was a bit difficult for the users. And Spotify tried to enable the search for listeners to find the music that they might like by playlists. So what you can do is you can make your personal playlist. So you can music that you might like, or you can follow other people's playlists, so that you more easily find some music that you want to listen to. But Spotify also makes it itself, so editorial playlists facilitate this search even more, and now also automatic playlists. That means that they are made on an algorithm. So Spotify, of course, has a lot of data on her users, and can use that data to try and give you music that's the platform thinks you might like based on what you've listened to before. These playlists are very, very popular. I think about 30% of all streams on the platforms are streams through the playlist. So a lot of users use a playlist to find music that they might like. So that also means for artists, it's a very good thing. If your song is being added to today's top hits, a very popular playlist, that increases your streams by about 20 million. Of course, that means that your royalties are being increased a lot, but also not very short-term thing, but maybe some new listeners find you, they see they might like your music, they follow you, listen to your music even more. So it's a bit of like a really stepping stone to launch a successful career, which means that it also became more important for artists. What did Spotify do? Try to commercialize on that success a bit by creating the discovery modes. This is a tool for artists which they can use to influence the algorithm that Spotify uses to promote songs to users. So as they say themselves, it's a tool to help you find new listeners. So if artists choose to use a tool, they have a bigger chance of being added to playlists of users who Spotify thinks might like your music based on their data. This should increase your streams and thus your revenues. Again, that does not come for free. If you want to use the discovery mode, you will receive less royalties than if you would not be using it. So Spotify takes some sort of a commission on the use of this discovery mode to kind of promote your music. There's no upfront cost, but there's only a cost if your song is being played, being the fact that you get less royalties than you normally would have. There are also some biases in the algorithm. A recent study by the CMA in the UK tried to go into that a bit more, but I'll mainly focus on the royalties issue. So the discovery mode practice kind of reminded us about the payola practice, which was quite popular when people listen to radio still a bit more than today. That meant that radio DJs were getting paid, were receiving gifts to play certain music in their programs. Which became kind of an issue because, of course, they didn't choose the music because they liked it or they thought their audience would like it, but only because they were being paid for it. So they had to be transparent about it. Now it's a bit less of an issue. But the payola thing, what we call here the discovery modes, is a bit the same thing. Because you're paying Spotify essentially to put you on a playlist so that you will have more listeners. Now, according to some, this would have benefits, mainly fostering competition. So what they mean by that is that artists who do not necessarily have a large budget can also use this promotion tool because they don't have to pay an upfront cost. But of course, they do receive lots of royalties, which is again one of the risks that were being pointed out here. If you have limited budget, you don't have to pay upfront, but still you receive less royalties. So maybe you won't be able to survive on your music anymore using the discovery mode. There's also a lot of pressure on artists to use this tool because of the fact that playlists are so important and using as a stepping stone in artists' careers. It also leads to an exclusion of non-paying artists from the playlist if more and more people start to use it, which would then again lead to a race to the bottom because people would lower their royalties even more until maybe nothing's left. And then the last concern relates to premium users. Those are users that pay the platform a subscription every month to not receive any advertisements. But we argue that this is kind of an advertisement on its own because Spotify is being paid to promote this music to users, also premium users, without being transparent about it. So we analyzed this from copyright and computational perspective. For the copyright, we started with the Digital Single Market Directive, for which Article 18 would be relevant concerning the fact that this obliges fair remuneration for artists. We however, think that it will be quite difficult to argue that artists do not receive fair remuneration, mainly because it's very unclear what fair is in this regard, and because there is a service in exchange for the artists. Article 19, on the other hand, might provide some help for artists because you can request additional information from Spotify. That information could relate to which playlists are you being added to, for how long, and what they estimate that the revenue of the discovery mode then will be. The idea is that this could put you in a more stronger contractual negotiating position towards your own contractual partner, for example, the recording companies, so that you as an artist can try to negotiate a fair remuneration yourself a bit more. Issue here is that member states can choose to oblige artists to request this from their own contractual party themselves, which we think kind of take away the idea of this obligation. Belgium, unfortunately, did not do this, so Belgian artists could use it to invoke this to Spotify directly. Then we looked at the DSA as well. This mainly gives transparency obligations to platforms. They would have to be more transparent in how they make revenue out of the discovery mode, how much revenue that will be. So again, artists can estimate whether they're still being paid fairly or not. And also transparency obligations. This is more relevant for users, as Spotify would have to say when something is an ad, and so also when something is using the discovery mode. Currently, there's a very small thing in their terms and conditions stating that financial considerations can influence the algorithm, but it's not specifically saying when or which songs. And we think that will be necessary to really comply with this transparency obligation. Just a small side note, the DMA is not applicable to Spotify as it is not considered a gatekeeper from the Commission's perspective. So those requirements do not apply to Spotify. Then we looked at competition law a bit more. First of all, we thought about Article 102, to try to use the abuse of dominance prohibition towards the Spotify practice. But we think this might be quite difficult. We don't think that you could argue that Spotify is a dominant company. We tried to estimate their market shares, but we only had access to data of its market shares globally. So you don't really know in the European market for music streaming services whether it would be larger, but globally it's only 30%. So we think that the chance that the Commission thinks its dominance would be quite limited. Also useful is that its market share are decreasing the past years, which we think is an indication that there is competition in the market and that Spotify would be difficult to see as a dominant company. Also important is that there are quite strong competitors, Apple Music and Amazon Music, which mainly have much more financial capacity than Spotify because they do not only run on their music streaming service, but rather have, as we know, lots of different things that they make money off, whereas Spotify really only has this platform. So we think Apple and Amazon, they could run on losses concerning the platform for a few years, whereas Spotify would be a bit more difficult. So we don't think it will be seen as a dominant company, but maybe what you could use is a prohibition of abuse of economic dependence under Belgian law. There are other member states who have similar prohibition, but we, for obvious reasons, chose the Belgian prohibition for this analysis. So we think that you could argue that artists are economically dependent on Spotify for different reasons. As I already said, royalties from streaming are a very important part of artists' budgets nowadays. So platforms in general are very important for artists to make money out of their music. And Spotify in particular has a very large amount of users, has quite high-tech technology and a lot of data on its users that it can use to promote your music, which puts Spotify in quite a strong position as opposed to the artist. The discovery mode then, finally, as I said, lots of pressure to use it because of the importance of playlists. And these three things taken together, we argue that you can conclude that artists are economically dependent on Spotify as a stronger actor. Then the question is there an abuse of this relative dominant position? Again, a little bit difficult. What we think you could say is if Spotify takes an unreasonably high commission, which could be the case when there is race to the bottom, they could say that this is abusive. But you could also say maybe the double dipping in itself is an abuse already. What do we mean by this? Spotify makes money out of its monthly subscriptions and advertisements, but they, of course, couldn't be doing that as long as if there was no songs on the platform. So they need to use the artist's music to make money. Using the discovery modes kind of makes them double dip, like making money twice because they're still using the songs to make money, and they make extra money because they promote those. You could disagree because, of course, as I said, there is a service, there is an exchange, Spotify is doing something for the artists as well, so it might be a bit difficult. But the main issue here is that this can only be invoked by the contractual parties, so the recording companies or other commercial intermediaries, who we think have less incentive to actually use this, because maybe if they feel like they're having to give too much royalties to Spotify, they might just lower the artist's cuts and make themselves stronger. Of course, it's only relevant for small artists and not really the ones that the recording companies would not want to lose. So for small artists, there seems to be quite less that you can do with this prohibition. Then what we suggest, we gave two alternatives in our paper. You could put a cap on the number of places on a playlist that can be allocated through the discovery modes. That way there will still be places left that are for free, so that you would not have to pay for. On the other hand, this might increase the chances of race to the bottom even more, because then the ones that are being allocated through the discovery mode might become more expensive. Or you could put a cap on the commission that Spotify is allowed to take from the royalties, so to avoid that artists not get a fair cut anymore. So to wrap up and conclude, the importance of streaming services and specifically playlists it's growing and puts artists in an economically dependent position of the platforms. Although they have to provide more transparency in how they operate, we think there's less help for artists, both from a copyright and a computational perspective, to really do something about the discovery modes. So in that regard, I think there's less that you could do. that was all. So if you have any questions or suggestions, please let me know.
Thank you very much. There's lots to reflect on this. So I hand the floor to Juan Pablo for his comments.
Thank you, Thomas, and thank you, Justin, as well. Can you hear me well?
Yes.
Okay, perfect. So I took some notes of my comments to the work of Justin, and if you allow me, I would like to read them. The first thing is that I really enjoyed reading the work of Justin, since not only as a lawyer, but also as a user of the platform of Spotify. And I think it's very interesting to know this information in order to have a more conscious use of the app. And one very important point for me was the topic about how Spotify is doing upstream. I mean, not in relation to the users or consumers, but in relation to the artists. And I think this analysis is related to the new trends of competition law that we are seeing also in the US, for instance, with workers and other economic agents in the upstream markets. And it's a question of not of monopoly power, but of monopsony power, if you may say. And I think an important case that is related to the discussion is the rejection of the merger between Penguin Random House and Simmons Chester last year by a district court of Colombia. And there, the reasoning of the rejection was based on the argument that the increasing purchasing power of these two editorial houses, Penguin and Simmons Chester, would result in lower payment for the artist. And I think this logic is very interesting. And I agree with Justin that competition law could do something about it as well. Mainly because apparently copyrights are not enough for providing an adequate compensation for the author because of many reasons. Enforcement cost, the atomization of the artist, the difficult to control the digital dissemination of their works and stuff like that. I'm also agree with Justin in the sense that there are certain challenges from consumer law perspective regarding the advertising use of this discovery mode tool for Spotify. And also, I'm also agree with the transparency requirements that you could also claim from Spotify from that side. However, and only just for providing some conditions for discussion and maybe some elements that could be used by Justin to further elaborate on her research, I would just want to mention a few points. The first one is that if Spotify is not a gatekeeper and if it's not in a dominant position, as Justin suggests in her presentation, then I think it would be hard to impose neutrality obligation or fairness obligation as cap limitations to the commissions or somehow an intervention of the algorithm, because I think those could be two strong remedies for a company that is not dominant or that is not a gatekeeper. However, I'm not familiar with the figure of abusive dependence in Belgium law, so maybe that is a way to do that. But at least in the general competition law, I think that won't be easy. And another thing is that while Spotify is indeed important for emerging artists, I don't think that the platform itself complies with the requirement to be an essential facility. And although there are network effects here that are important, I think that the service can be replicated by other streaming services. Even the discovery mode could be replicated, I guess, by, I don't know, Apple Music or Amazon Music. And moreover, I think there are other structural aspects of this market that somehow Justin also mentioned that in her presentation, but I just want to highlight them. The first one is that Spotify has a mutual relationship of dependence with the music companies, the music labels, especially with the three majors, Sony Music, Universal, and Warner. And even though the market share in the market for revenues of streaming music of these three majors have decreased in time because of the increase of the streaming services as Spotify, they still have the big portion of the pie, according to at least the CMA's market study of last year in 2022. So yeah, Spotify somehow is disciplined by the countervailing power of these three major companies. And a second structural aspect is the relationship with Apple Music in particular, because as Justin also suggested, Apple Music is integrated in a very important ecosystem of Apple, I mean, App Store and the iOS operating system. So it's not easy for Spotify to compete with Apple Music because of these structural advantages that Apple Music has because of the whole Apple ecosystem. And that is something that you also must consider in detail in this competitive dynamic. Another point that I would raise is Spotify incentives. Spotify is a two-side market. On one side, you have the users, on the other side, you have the artists, and Spotify obtain revenues from both sides. So I think you may say that Spotify has incentives to somehow balance the benefits from each side. So if Spotify start to increase that much the commissions for the artists, for instance, then the artists will be, I guess, will have incentives to change their catalog to another platform. I'm talking about the artists, but I'm also would be talking about the music labels that has the rights of the artists, and they just can deviate the demand to another competitor, and that would be harming or will harm Spotify because the platform would be less attractive for the users. So the two-side equilibrium will be also an important thing to consider. And finally, I'm not sure if Spotify really harms emerging artists, or I mean artists that has bad financial situations, because as my understanding goes, if you subscribe to the discovery mode, yes, you have to pay the commission to Spotify, but that commission is calculated from the increase in streams that you get because of this algorithmic push or benefit in autoplay and in radio automatic playlists. So you only have to pay if you get more streams, and even after you pay the commission, then you keep the benefits of this increase of the streams. And if you don't get any more stream, if nobody hears you in this playlist, then you don't have to pay anything to Spotify. So at that level, I would say that it's not clear for me how discovery mode is harming these artists. And the final point is just to mention that Spotify does not require to the artist to subscribe exclusivity provision or a single homing clause. So the artist is always free to promote their work in other platforms as Apple Music or Amazon Music, but also to promote their works in social media and using their own means. So that freedom is also something that you should consider when analyzing this tool. So that's where the issues I wanted to raise, and I hope that any of them could be useful for Justin. So thank you very much.
Thank you very much.
Thank you very much for these very thoughtful comments. I think you have set up the arena very well for the debate. Perhaps before you respond, we look if there are some other questions.
I would actually like to follow up, particularly on that last point that was made. During the whole presentation, I was actually trying to find out where is the core of the problem, right? If you could say, is it with the playlist as such, or only the discovery? Well, with the fact that we have the playlists, of course, works a bit like a Champions League, right? If you're successful, you become even more successful. And yeah, there's maybe more inequality for the artists, but yeah, that's just a natural thing. There's no way around it, I guess. So is there anything wrong with the playlist as such? But then also I was thinking about the double dipping. I think the discussant made a similar point in different ways. Here again, you could say, well, the popular artists will earn more eventually, right? So, and also the commercial distributors. So there's not a problem for them. Maybe if you are less popular starting artist, then you would be worse off. But I think the core of the problem is then, how do we know that the royalty would be too high? Where do you get that information from? So that seems to be somewhere implicit in your story, right? That we pay, or artists pay too much, or the distributors, commercial distributors. Is there hard evidence for that? I mean, there's hard evidence for the fact that it creates more inequality between popularity, but I mean, that's not your point, I guess, right? So what's the main point? That's, I guess, my question.
Yeah, I have a minor point. I was reading in preparation for my own talk, I was reading a lot about Taylor Swift. And actually Paul Krugman, his newsletter, talked about Taylor Swift. And the article was about whether she can charge too much, whether that was too cheap. Anyway, it was about the pricing of Taylor Swift tickets. But the particularly interesting part of this newsletter was that Paul Krugman pointed out that artists traditionally never really relied on publishers of music for revenue, but mostly on live performances. And he was going back 150 years to rural America, where he sort of looked at the price of a concert and said, well, in proportion to people's incomes, people back then paid more for the concert, and as a result of that, it was a massive part of artist income back in those days too. So maybe an interesting historical perspective of how musicians make money and how they relate to those who distribute music.
I have a very kind of, I don't know, technical, stupid question. So at the beginning, you had this kind of 3-layer structure, but that didn't show up afterwards anymore. So you basically talked about the relationship between Spotify and the artists. And I was wondering to what extent this middle layer somehow changes the perspective or changes the outcome. So I'm thinking, if you would run an abuse, let's assume dominance and whatever, is it that they're abusing the artist if you would run it as an exploitative thing? And then I suppose the same thing goes then for the Belgian law. And I have very, very little understanding of these cases of relative dominance, and I have looked at them. So, but there is the same question. There is this kind of layer in the middle. Does that change the outcome, or how do you factor that in?
Lots of questions. Let me just add one from my side, but which goes a little bit to the question also, where might the problem be? I think you have been looking a lot at the sort of, an unfair price or an exploitation, but you looked under the copyright rules, you seem to say, like, we can't really say it's unfair pricing on the copyright rules. But you seem to be a little bit more open to say it's unfair under the economic dependency rules, and should that not be coherent? So, like, if it's unfair on the copyright, yes, then it's unfair on the economic dependency. But if it is not unfair on the copyright, how could it be unfair on the economic dependency? Should it be the same standard? And then perhaps to flip it around, is like, are we thinking about the artist, or should we think about the user? Because I think you hinted at that too with the Payola issue, that the user gets recommended songs for which people pay, which may not necessarily be the best songs. Like get a Taylor Swift song instead of AC/DC, which is horrible. If she pays, AC/DC not. And so that seems like some sort of harm, but is that something that would be caught in your yes.
Okay, thank you all for your very interesting questions. I think it allowed me to elaborate on a few things that we went into in more detail in the paper that I didn't have time for today. So that's great. I'll try to maybe bring some things together that you asked about. So first, as you mentioned, the countervailing power of the intermediaries, which is a bit also your question, I think. So it's true that the recording companies have a very strong position. The three major recording companies that have indeed 70% of the market share in
that market for recording companies. So that's huge, and they also have a huge portfolio of artists, of course. So that puts them in a very strong position towards those smaller artists. So taking your questions together, I'd say it is indeed a very important layer to take into account the commercial intermediaries, and especially those recording companies. We thought about how Spotify and the recording companies work together and how that also affects the relationship with the artists. Very difficult to analyze how that goes. So that's why we decided to focus specifically on Spotify. But I think you could say that those two very strong actors taken together actually really weaken the position of the artist even more. So the artist indeed only has a contractual relationship with those commercial intermediaries, making it very hard to rely on the economic dependence prohibition in Belgian law towards Spotify, but also makes it harder to say that there's an abusive dominance towards smaller artists. But maybe that could be part of the problem, because they are both very strong and also intertwined, because as Spotify first launched, they actually got shares in the Spotify company in exchange for giving them the license to music. So there's a bit of a fake and ambiguous relationship a little bit that makes it, I think, even a weaker position for artists. So in that regard, I think it would be even more relevant to use maybe competition law or copyright law to strengthen their position a little bit, for which, yeah, in some cases they can only go to the commercial intermediaries as a contractual partner to try and have them comply with certain transparency obligations. But I think in this case, it is a bit like a dominant position by the two together. You might try to argue that, but that's of course more difficult from a competition law perspective. So that's why I focus on one party. Between Spotify and the commercial intermediaries, I think, yeah, there doesn't seem to be that's much of a difference in terms of how strong they are towards each other. So I agree that you say that that's a contributing power indeed. So Spotify towards those intermediaries, I don't think you could say that they really are in a dominant position, because indeed they have to negotiate with them and have their music, otherwise platform would die out soon. So in that regard, there is more of an equilibrium on that aspect, and not really towards the artist anymore. And then Apple Music, as you mentioned, indeed a very important competitor, changing the market structure a bit. But at the same time, so I do agree that makes it more difficult to see Spotify as a dominant player. But as you mentioned, since there's no single homing or any obligation, yeah, artists probably have to be on all platforms to reach a bigger audience. And if you are a very important artist, yeah, then you will probably be able to negotiate more with Spotify. And like I think Adele did, that you couldn't go through her songs in a different order. You need to listen to the whole album in its entirety. But for smaller artists, that's of course not possible. So they will probably use those different platforms. And then there is some competition, but also, I mean, to a limited extent, because I don't think Spotify really is on a risk of losing artists when using things like the discovery mode. So that's also a bit like the other thing you said about two-sided markets. They have an incentive to keep the artists with them, but for smaller artists, that incentive is way less, I think. If Spotify would lose very big artists, then I think that they might change their approach a bit. But for smaller artists who are using all platforms, I don't think that would work for them. That is there a harm for artists concerning the commission, which I think was also a bit Niels, your question. Important to remember here the royalties that they have to give up for Spotify are, it's not very clear how much it is, because again, transparency issues relating to Spotify, but it is at least 30% of the royalties that they would have to give up, and some say it's even 50%. So that really is a big cut in artists' budgets, for which I think you could say, like, if it's that much, 50%, that's, I mean, that's half of your what you thought you were going to earn. So in that case, you could say that there is a clear harm for smaller artists. And it is true that it's balanced out because you get more streams, but I mean, then you would have to at least double the streams already, given the fact that you give up 50% of your royalties. So that's quite a lot, I would argue. Let's see.
Then the Taylor Swift question that you raised, did she ever charge too much? So she probably can charge how much she wants. But also what you said about live performance, which is a big chunk of an artist's budget. But I maybe we looked at different research, but the reason I was saying that actually is going down for smaller artists that need quite a lot, whose budget is now more streaming services and live performances to really a lesser degree. But maybe that changes for big artists quite substantially. But at least for smaller artists who often start by using the platform and then after they grow are able to do live performances and actually charge for that. For those, the streaming services are still, I think, a bit too big of their financial capacity. Then the final question, I believe the when is unfair, when are artists being paid unfairly? Well, when I looked for the copyright perspective at the DSM, it's mainly that it's unfair in the text of the DSM what fair remuneration is. They give very vague standard or thresholds, but most people in literature seem to agree that artists have to be able to live all from the music, and if that's not the case, then that will be unfair. But I think both for copyright as for competition law, there's a bit more a bit vague as to what the fair thing would mean, and you still have some room for discussion. We didn't want to go too much into the DSM way because it's, there was so much vagueness in the text, and also because it's quite new, so we didn't have anything to rely on. For the Belgian prohibition on economic dependence, it's also still relatively new, but there were already some court cases available. So we tried to navigate those a bit and see whether we could rely on those two to argue that was unfair. But again, I think it would be difficult to estimate whether a judge would accept it that the commission is paid unfairly. So also what we say in the paper, it seems to be that you could only use it really if it becomes a race to the bottom and if you barely have anything left. But in that case, I think I agree that it would be better if copyright and competition law have the same perspective in that regard. So maybe some more clarity could come. And he also asked, should it be the artist or the user to take into account? Well, we mainly looked at it from the perspective of the artist as the B2B relationship here. Of course, it is useful for users to have this type of discovery mode. That's also what in the CMA paper came forward, that users were actually quite happy with this because they got to know more music that they liked. So from a purely consumer perspective, it's not necessarily problematic, as long as it doesn't, of course, need to affect like small artists might be competed away because they have no, they can't survive on their music. Then in that case, in the long run, this won't help users either. So I think I hope I've answered all of your questions. Thank you very much.
Very well, thank you very much. Okay, so we move to another hot topic, computational antitrust and IP in the tropics, with Juan David.
Hello, everyone.
Share the screen, or do I still need to give you the rights?
Yes, I will share my screen. You're listening to me properly, right?
Yes.
Oh,
Yeah.
I don't have the authorization for screen sharing.
Multiple participants can share. No.
No, you just go to make it with co-host. Go to participants, and make a co-host. Oh, for him, yeah. On the right.
Three dots on the right.
And the other one, one away.
No, on top.
All allowed. Okay, yes. And do it like this. So, yes.
Yep. Okay. All set, right?
Yeah.
Well, let me start by thanking you for staying until the very end of this conference, for this panel, and thank you everyone who's involved in the organization of the conference. Okay, as you know, I'm going to present about how computational tools are being used for legal analysis and semi-automation of law enforcement, both in antitrust and IP. It's a case study about the Colombian Competition and IP Office. And my agenda is the following. I'll give you a few data points about the context that is, you're probably not acquainted with the Colombian competition or IP laws, or I'll give you just basic facts about these sets of law. And then I'll go right into 7 different tools that were developed and used by the competition/IP office, because it's the same agency that does both works. And then I'll just deliver 3 takeaways. So let me start with the context. Well, Colombia's competition law and IP law has many decades of existence and enforcement. So, for example, the competition law dates back to 1959. The first cartel fine, just to give you an example, was issued in 1961. So there's several decades of experience enforcing the law. Since the middle 1970s, the agency in charge of enforcing competition law and granting patents and distinctive signs is the, I'll say it in Spanish, Superintendencia Industria y Comercio. From now on, it's just the competition/IP office. It's an administrative body. It's part of the national government. It's not particularly independent. On the side of competition law, it both prosecutes and adjudicates cases, and it has all the regular tools of investigating and sanctioning antitrust practices, also conducted merger control and competition advocacy. On the other side, on IP law, very similar story, many decades, even almost centuries of managing this law. And in Colombia, we have 2 separate intellectual property authorities. The one that I just mentioned, the Superintendencia, is in charge of industrial property. And then there's a separate copyright office that works absolutely separately. So I will deal with what the Superintendencia does with regard to computational antitrust and IP. Again, just a bit of context, just bear in mind that Colombia is just one of many other national jurisdictions in Latin America with competition law and IP law. So here you see a map of 32 national and supranational competition agencies in Latin America. There's great divergence in the capacity of enforcing the law. So this is just an example. The number of cartels fined in Latin America in the last 20 years. Colombia is second, just behind Brazil. But there's a lot of variance you can see in the capacity of the agency of enforcing the law. So that's the context. It took me 3 minutes, but I think it was worth to give you an idea of where these tools are being implemented. So let me then begin the bit of the computational law. So what's computational law? If you're not acquainted with it, it's concerned with the mechanization of legal analysis. But if you want to go a bit further, it's even more than just mechanizing legal analysis. It also automates or semi-automates the enforcement of the law. So whenever I speak about antitrust and IP computational law, I mean either mechanizing legal analysis or automating enforcement, or at least part of it. And of course, this is more or less an emerging literature. In the last years, we've seen some publications, particularly more on the antitrust side than in the IP side, of how antitrust agencies are developing all sorts of tools to analyze and enforce the law. So that's also a bit of the context of where the literature is at now. And just to give you an idea, the last Stanford Computational Antitrust report that was published a few weeks ago, it has 26 contributions from 26 agencies around the world. So it's growing, and it's, as I'll explain today, it's not just limited to the big wealthy agencies, but also small agencies are doing their bit. Another thing that I wanted to let you know is that this project, which is just work in progress, is part of a broader project that I'm working on, and I've been working for 2.5 years now on automated decision-making systems in the Colombian public sector. And I recently published a database with 113 automated decision-making systems that are used in many sectors. This is actually, oh, maybe this is too small for you to see, but this is more or less how different sectors within the state are using these automated decision-making systems. One of the sectors that use it the most is the economic affairs sector, which includes the competition/IP office. So it's not surprising that we see that the Colombia's agency has developed 7 tools. It's part of a broader context. So let me now go to the tools, since I have around 9 minutes. So it's 7 tools, as I said before. There's 3 antitrust tools that are developed and are being currently used. There's 1 in an early developing stage. I will explain each of them in a few seconds. And then there's 3 IP tools, 3 of them and oral currently in use. So as you see in the brackets, they are relatively recent. The oldest one that it's operational is a 2020 tool, and that data analytics tool. But as you can see, they're quite new. But there are some precedents that are worth mentioning. So in 2013, the economic studies group of the Superintendencia developed a project that aimed at tracking public procurement data to identify patterns of potential collusive behavior by bidders, and they managed to pilot it in a few key public bodies that have a huge deal of resources spent through public bidding, but it was discontinued. We'll see that one of the new projects builds on it, but 10 years ago it was discontinued. And then 5 years ago there was a price tracking system that was developed not by the competition agency, but by another unit that was interested in developing data analytic tools for the state. And they developed a web scraping tool for tracking supermarket prices. They gave literally the tool to the agency, but unfortunately at that time the agency was not very sure how to use it. They were not sure that it was worth it, so they basically archived it. But then again, a new tool was developed a few years ago that builds on it. So actually, I'll start with this. The tool is now called Sabueso, which means hound in Spanish. And it's a price monitoring data tool. Currently, it's used only for supermarket stores that have e-commerce platforms, particularly websites where they offer their goods. And it's tracking prices to create a database where they can identify patterns that may raise suspicion. Up to now, we don't know if the agency has started investigations due to this tool. There's currently no supermarkets investigation, but we know that because of their reports, they are currently monitoring 5 different big supermarkets, aiming at detecting potential cartels. And the system, the agency does not offer too much information whether they are only interested, for example, in price parallelism, or if there's more than that. That's something I have to research more. One thing that I have to say is that I have conducted some informal interviews, but I have to conduct more formal interviews to answer some of these questions, particularly of how the systems work. There's a second system called Inspector, and it's a web scraping tool that monitors websites of regulators, and it's coupled with a natural language processing model that analyzes the texts of the projects, and this model was actually trained with the reports produced by the agency that are part of their competition advocacy work. So I guess this one I need to explain you a bit more about actually the competition advocacy mandate, and it's the following. The Colombian agency has the capacity of producing reports to recommend changes in regulatory projects that may affect the competition dynamics in a market. And regulators are obliged to notify the agency before they issue the regulation so that the agency can actually participate beforehand, before it's issued. But one of the problems that the agency found was that there were several regulators that were not informing about their projects, and the Superintendencia stated that their staff was using a lot of time just checking websites manually to see whether there was new regulatory projects that should have been notified. So this tool web scrapes and analyzes the text to identify through keywords whether there are there could be a project, a regulatory project that has not been notified and that could affect market competition. This is actually widely used. They are monitoring around 60 regulators that have websites, and they say that it's helping them a lot for that purpose. There's a third tool called Sherlock. This is very similar to the one that I mentioned at the beginning of the precedent, because it aims at identifying potential bid rigging. It had a first phase in which the tool only helped public officials, the superintendencia's officials, to collect and process data on public procurement processes and to filter the data, because unfortunately at that time, at least, the e-procurement platform of the Colombian state was not very useful for the purpose of actually looking for insights about potential bid rigging. So they had their own tool, and then a second phase that is currently being under development. It's actually more data analytics to identify patterns in public procurement processes, to identify who is participating and when it is not participating in similar bids, and how they present their tender offers. So I know I only have 3 minutes, so I guess I'll have to move on more quickly. There's a fourth tool that is under development. It's called Búho, which stands for owl. And it's also a web scraping tool that aims at analyzing news reports and information that circulates online that could somehow give clues about anti-competitive behavior. So it uses keywords that could appear in websites to generate alerts and to red flag whether there's something that the agency should look at. This is work in progress, so there's very little information, and I have lots of questions of what keywords they're using and so forth, but they have disclosed little information about it. Okay, moving on to the IP world. These tools are useful not just for public officials, but also to users. In this case of the CLASEPA tool, that it stands for Patent Classification System. It's the users would be patent requesters and public officials as well. And it's a machine learning algorithm trained with historical data of patents that have been granted in Colombia that recommends the user how to classify the patent in terms of the international patent classification. So it helps to present the patent submissions, and it's quite straightforward. And then there's another, not for patents, but for distinct enzymes, and this is a machine learning algorithm that assesses texts and image from existing distinctive signs, and to calculate the similarity with signs that would be part of a new application. So the users of these systems is not just the requesters, but also the owners of the rights. If, for example, they think that maybe there was a submission and they want to check through the tool the degree of similarity of the requested sign with their own sign. And of course, it's also useful for public officials. So it assesses both the text and the image of this distinctive sign. So I think to wrap up, because the time is over, 3 takeaways. The development of computational tools is part of a greater ecosystem. So it's not just a competition agency in Colombia, but it's the public sector in Colombia that has developed tools for different agencies to either acquire or develop their own tools. So it's not an island, it's part of an ecosystem. Secondly, it shows, this comparative case study shows how data analytics projects are feasible in developing contexts. It illustrates how antitrust and IP offices can reap benefits from it. In Colombia, there's even space for further use in merger control and on retail and on price maintenance, retail price maintenance. So probably in the future we'll see more tools. And finally, there's a big question mark on the impact of these systems. They have not been formally assessed, but they're very new. But it would be pertinent because, as probably you are aware, algorithmic tools may be prone to bias. And although this is probably more important or more pressing when it's about human beings, which are subject of the analytical assessment, of course, antitrust law and IP law is more important probably for firms, but there could be bias that should be cared for. And this is it, and thank you very much.
Thank you very much for this fascinating presentation. I guess the immediate question that comes up in my mind is when will we have robot antitrust enforcers? But I hand over to Pratiksha for her observations.
Can you hear me? Is this clear? Is this loud enough? Okay, perfect. I know we're only short of time, so I will keep it super short. Disclaimer, after I got your presentation, I did quite some research into you. Borderline stalking, and I did read a lot of your research. Again, so what I'm presenting is from a devil's advocate perspective on AI. We all like AI, we all like to make our lives easier, but let's be critical here. The perspective I take is one from Jurassic Park. Just because you can do it, does that mean that should you do it? Yes, they are using such AI tools. It can be done, but should it be done? Which leads to my second question about the use of data. You allude to in your abstract about certain databases that they are using, that they input into such algorithms to generate with help of AI. What about biases in the database itself? You talk about one of your impacts in your conclusion is algorithmic bias, but what about biases in the database that the machine learns? Can it unlearn such biases? Because if there are some patents that were granted, let's say in the 1800s and now they're not anymore, can it unlearn such biases? In the beginning, you also give us an overview of copyright laws and IP laws. Maybe this is a next step forward that will benefit your paper, a discussion about data laws and AI laws. Because in the EU, we have a lot of discussion about GDPR, and that's the cornerstone for everything in relation to data. I know that Colombia has a 2012 legislation, maybe a certain reference to that. And the last question is based on 2 pieces of your previous writings. One about your writing regarding the case law, the case that Colombian judges used ChatGPT, where you said, well, is this the way that we take AI forward? And where are we seeing AI use such tools? And what's your take on this? And the second one is, if such a database plus algorithm tool works, with computational copyright and IP systems, can we take this forward using other databases, including agricultural databases? Because a lot of your work is based on other fields, and from another global South country, what is the implication for other sectors? And with that, I'm done. Thank you.
Thank you very much.
Very, very concise.
Thank you very much. Thank you for the discipline.
Well, thank you. Thank you.
We have actually indeed, and we have actually still some comfortable time for discussion, but we open the floor for questions.
Juan David, thanks a lot. Good seeing you again. Too bad that it's only via Zoom again. But let me also play a bit of a devil's advocate. You basically showed us what those things are supposed to do. If I'm a parliamentarian, I'm wondering, is that money well spent? And you say that the agency is tight-lipped. Is that all just for show? Can we expect results with these tools? Or is this just like people playing around with public money?
Yep.
Other questions? And perhaps, like, if I may, sorry, this.
First of all, can you hear me?
Yes.
I have a question about machine translation. I think machine translation is arguably the most prevalent use of automated decision-making tools in perhaps patent application. And I used to have a colleague who did machine translation and patent filing regarding cases where the patentee filing is coming from Eastern Asia. So the language barrier is not something that you can overlook. And with the language barriers often come with a connotation of the scope of the patent. Therefore, machine translation gives a version of a patent whose scope is undetermined by the patent by the officer. So I was wondering, do those automated tools share this, let's say, black box, like machine translation, and what could be the possible cost of this pattern of these automated tools? Thank you.
Any other questions? We have one last question then from me, and that goes sort of a little bit to the relationship of these tools, or some of these tools, to decision making. Right? It's like in antitrust, I think I found it very interesting your reference to the tool that is trying to discover cartels from price data. And we know that there is obviously there can be tacit collusion or tacit coordination that is perfectly lawful, but leads to aligned prices versus a cartel that, you know, sort of on a first order might have exactly the same pattern. So how do you distinguish between the two? Is this just a kind of first filter then, and then you will have to do your investigation, or will you immediately write the fine once you discover the parallelism in the price? So that's an antitrust, and on IP, so particularly interesting, the one on trademarks, which looks for similarities. And similar there, the question, if the machine throws up a similarity, will then, you know, automatically a decision come that you can't register the trademark, or is there still human evaluation? And what's the weight there then in something like a similarity assessment? If the machine says, I think this is very similar, can the human decision maker override, or, you know, does he have to have another reason to override? Or what's the relationship to the human decision maker?
Great. Well, thank you everyone for your comments, and also thank you for the discussion. I'll try to address all of them. The first question, the Jurassic Park question, whether should we do it just because we can do it? And I think that's, of course, a greater question nowadays in AI, right? It's not about this. It's actually quite useful that our colleague Holly Sargent published yesterday a paper called Unleashing the Power of Algorithms in Antitrust Enforcement, Navigating Boundaries of Bias and Opportunity. She published this in Competition Policy International. So, and I read it actually this morning, just before this. And I thought it was very interesting because it compared the problems of bias when AI is used to study human conduct, like human beings, rather than studying firms' conduct. And one of the interesting points that she raised is that she said, well, competition law is already by design biased against certain companies, market power companies, right? Dominance companies. So it wouldn't be surprising if the tool is implicitly already including some biases against certain companies which have dominance. So that means that bias is something that we have to take care by design, not just, I mean, of course, not just checking whether the results are biased, because, for example, as Pratiksha said, databases can be unbalanced and therefore produce biased results. But instead of just checking whether there's bias and see how to solve it, bias has to be addressed since the design. How will we collect the data? Which data will be used to train the system? If it's a machine learning system, how does the model work so that it doesn't have explicit biases? And bias is something that will always be a challenge for this system. I think that it would be great if you could also read Holly Surgeon's paper, because she argues that this sort of bias is less problematic in antitrust because of the fact that we're dealing with companies, and discrimination against the companies is not related to, let's say, religious, political, ethnic, or any other background. But at the same time, she says that since competition law already discriminates against certain type of companies, then we will probably have to live with it. Pratiksha also mentioned about data loss. So incidentally, the Superintendencia is not only the competition agency, the IP office, but it's also the data protection office. So it has everything in its hands. And Colombia has been enforcing a comprehensive data protection law for over 10 years. And we're starting to see cases in which competition law and data protection law intersects. So I think, yes, there's scope for research on that. About ChatGPT, I've written a lot about ChatGPT, in part because in November, I was very worried about my students using it to draft their essays for my classes. But then in January this year, a judge in Colombia surprised me because he copy-pasted 4 questions/replies that he made to ChatGPT to substantiate a ruling. He literally made 4 legal questions, copied the answers, and it's 70% of the ruling, the ChatGPT text. So I've written a lot about that, and then other judges in Peru, Mexico, Bolivia followed up, so it became some sort of a ChatGPT fever. And I was very worried because, or I'm very worried because the judges that use the tool clearly did not understand how the tool worked, did not understand what were the limitations of the tool and the risks of the tool. And that's, of course, very worrisome. They use the tool as if it was an oracle. I wouldn't say that they just based their decisions of whatever ChatGPT answered, but it was clearly influenced by what ChatGPT answered, and it was not clear in their decisions how they checked whatever conclusion or statement was included in the synthetic text with other more reliable sources. And turning back to the paper I presented today, or the working paper I presented today, better, in the superintendency in Colombia, the competition agency and the IP office they developed the tools in-house. So it's not an external tool, but it's actually developed in-house. That actually is related to Julian's question, which I'll address later. And it is used by and with the company of the people who developed it in-house, because the agency has engineers and economists who develop these tools. So it's different than ChatGPT, where we have little information about what data was used to train ChatGPT and how does it work in reality because of the opacity of OpenAI and its competitors. In contrast, the tools used by the Superintendencia, not only they were developed by them and are used in company of the people who developed them, that they know what data was used, and they can actually fix it when they find bugs and so stuff. So my worries about ChatGPT in the judicial system are different than these cases of the Superintendencia. Okay, about Julian's question. So AI is a marketing term. It is used to sell, right? I don't think that the Superintendencia is trying to sell anything. They don't refer to it always as AI. They are more, I think, precise. They say it's data analytic tools. Sometimes some of them are machine learning tools, but they don't use AI as a marketing tool, as it happens nowadays with companies. So I think that on that side, we can think that they are meaning to use tools for improving their work. But of course, it's always worth to ask, was this money well spent? And one of the things that surprised me about this case studies is what I've said already, and it's that the tools were developed in-house. Most of the tools that I mapped in other public bodies in Colombia, they were not developed in-house, but actually they were licensed by proprietary firms that have proprietary rights, and they cost a lot. So it may be the case that there's actually a small cost of these tools, given that they were developed in-house. But I think it is true that we need to check for results. And I think there's, as you saw, it's different types of tools. And I think some of them are already rendering clear benefits. The one that, for example, web scrapes and detects regulatory projects instead of a public official entering each of the 60 websites and check every day whether there's a new regulatory project. I think that clearly reduces the burden of work. So that sort of automation, I see how that helps them to focus on what's important, less like manual work and more conceptual work. Others are less clear. The ones that, for example, the new one that aims at web scraping social networks, websites, and everything to check whether there's anything that helps them find collusion or any anti-competitive behavior. I think that I'm not sure about that. I am not sure about the results that the tool. So I think fair enough, Julian. I'm not normally optimistic, but in this case, I'm a bit optimistic. There was a question about machine translation. Well, one of the things that are highlighted by the Superintendencia is that since the tool was developed by them, it is a tool that works in Spanish. And that helps them because the tools that are available out there are in English. So the fact that the tool was developed by the Superintendencia reduces this language barrier. But I have the same concern that you mentioned about how the tool anyway works as a black box in terms of analyzing text. How does the tool make the inferences, for example, regarding the scope of the patent? We don't know, and the people who train the machine learning algorithm don't know either. This is how machine learning algorithms mostly work, as a black box. So that's why, and jumping to the last question, None of the systems are used in a fully automatized way. They are all subject to human oversight or human decision. So it's, I mean, whatever the tool suggests or recommends is not immediately adopted by the public officials, but rather it's used as an input, a very important input. You would say that there may be some risks of automation bias. That means that public officials will simply do whatever the system recommends instead of them doing their own thinking. That can happen, but it's not supposed to be like that. And that's something that must be checked. That's a risk that must be checked. The topic of tacit collusion is quite interesting because in Colombia, the law explicitly states that a form of anti-competitive agreement is what in Spain and other countries in Latin America call conscious price parallelism. So that's explicitly in the law. The law includes not just concerted practices, but explicitly it includes a conscious parallelism. And in fact, most of the late 1990s and 2000s cartel cases were conscious parallelism cases, where the investigation started with a statistical analysis of the behavior of prices to find parallelism in prices in certain months or years. And that's how many investigations started. And there were many cartels fined with the type of conscious parallelism plus factors that we see in the US case law. But again, as I mentioned before, it's not automatic. So if the system finds price parallelism in a certain period, it doesn't mean that immediately they will initiate investigations, but they will probably start looking for additional evidence and then see whether it's worth opening an investigation. And I think I covered everything. So thank you for your time.
Thank you very much. And we're right on time. I think that concludes the panel. It's like, now it's what do we do? We go back to the main.